night on the CINA 102.3 app at cinafm.com, on TuneIn, on smart speaker, and at 102.3 FM. Cina Radio, every device, everywhere. The following program does not necessarily reflect the opinions of the management, staff, or advertisers of Cina Radio.
Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me, fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS, extension 100, or visit yourrights.com.
برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات، مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس، يأتيكم الآن على الهواء مباشرة. الله أوقاتكم بالخير مستمعي راديو سينا في كل مكان. تحية طيبة لكم، معكم رامي صادق وحلقة جديدة من برنامج يور رايتس مع المحامية جومانا كيروز المختصة بحوادث السيارات والإصابات الشخصية. الآن مكاتب المحامية جومانا كيروز تستقبل عدد كبير من القضايا، منها بالتأكيد البيرسونال انجريز والكار اكسيدنتس والإميجريشن والبانكربسي والكريمنال لو والفاميلي لو والسوشيال سيكوريتي، مع طاقم من المحامين المختصين بهذه المجالات. رقم الهاتف في مكاتب المحامية جومانا كيروز للاستشارات المجانية 248-557-3645. ودائما بإمكانكم زيارة الموقع الإلكتروني yourrights.com والاستماع إلى هذه الحلقات yourrights.com/radio، أو زيارة channel جومانا كيروز على اليوتيوب للاستماع مرة أخرى إلى هذه الحلقات. تحياتنا لكم، واليوم حلقة مميزة راح تكون أكيد مع واحد من المحامين ذو خبرة طويلة 44 سنة في مجال حوادث الانزلاق، المحامي هاورد راودنر. أكيد الحديث اليوم عن حالات الانزلاق. جمانة مساء الخير، أهلا وسهلا فيك في راديو سينا.
صباح الخير رامي لك ولكل المستمعين. صباح الخير للضيف طبعا اليوم المحامي هاورد رادنر. المحامي هاورد رادنر اللي هو محامي لقضايا الانزلاق اللي بنسميهم بالإنجليزي slip and fall و trip and fall. المحامي هاورد رادنر عنده 44 سنة خبرة، وفي جزء من هدول السنوات اشتغل عندي بقلب المكتب، وإنما حاليا عم يشتغل معي كل قضايا الانزلاق اللي بتجينا على المكتب. رح نحكي ليش هيدا القانون صعب كتير، ونادرا ما نلاقي محاميين ياخدوا هيدول القضايا. فنحن هيدول القضايا بنعطيهم للمحامي هاورد رادنر. بدون شك في عدد من المستمعين اللي اتصلوا بالمكتب واللي كانوا مع المحامي هاورد رادنر يا وقت اللي كان عندي بالمكتب يا حاليا، وكانوا كتير مبسوطين من النتيجة، لأنه هو من المحاميين القليلين اللي بسبب القانون الصارم هون في ولاية ميشيغان ما زال يقوم بقضايا الانزلاق، وبالتحديد الانزلاق إن كان بلاندلورد تننت، إن كان على السايد ووك، إن كان على ستريت، إن كان بقلب مولز، إن كان بقلب ستور إلى آخره. رح نحكي عن كل هالأشياء لمدة ساعة اليوم. نتمنى إذا شخص بحب يتصل يسأل سؤال أو يعلق، إذا بس بيكون الموضوع اليوم محدود بالسليب أند فول، تريب أند فول، يعني كمان مرة بالعربي قضايا الانزلاق. رقم التليفون هون هو 313-769-6666 و 519-256-1023. وبعد أيام قليلة منحط نسخة عن هيدي الساعة على الويب سايت تبعنا yourrights/radio وعلى Joumana Kayrouz YouTube channel. Good morning, Attorney Howard Radner. It is a pleasure to have you here today.
Thank you very much, Joumana, for having me.
It is our pleasure. I understand that you came from court. You had a settlement conference, I believe, earlier today in Wayne County.
Actually, that settlement conference got moved
Oh, got moved,
Yeah.
rescheduled.
Rescheduled.
Okay, very good. We were telling the listeners that you are an attorney with 44 years of experience. You specialize, you have created, you are one of the few attorneys remaining in the state of Michigan who does practice and makes a killing practicing in slip and fall and trip and fall. And in a minute, we will tell the listeners why. Because the law has gotten so tough as it pertains to people who are injured because they have slipped or because they have fallen into a pothole or whatever the case may be, that there are very few lawyers remaining in the state of Michigan who are wanting to take on those losing cases. You're one of the very, very few left. In fact, that's how I met you years ago when I did not want to practice slip and fall, and I was getting a lot of calls from clients who had, been injured as a result of a slip and fall, whether as a tenant and they wanted to know what their rights were against the landlord, or whether in a big store like a Costco or a Kroger or a Meijer or on the sidewalk of an apartment complex or on the sidewalk in front of a street or as a guest at somebody's home. And I interviewed a number of lawyers, and you were the one who stuck in my mind. And ever since, and that was over 10 years ago, or maybe about 10 years ago, ever since, all of our slip and fall cases are handled by you, and you do a very, very good job. Yes, you do turn more than you do take because of the law. You're very good at that, but you're one who knows the law very well. You're one who litigates those matters and goes to trials on a very regular cases, in fact, on a basis. In fact, not too long ago, you were in a trial, correct?
Yes.
A winning trial, correct?
Yes.
And so you have been handling our cases and very successfully for those that you take. What is if you have to approximate Attorney Howard Radner, what is the number of cases when you get 10 calls or 20 calls from our office? What's the percentage of those cases that you keep approximately?
Probably 1 to 2%.
1 to 2%. And that's not because you shy away from difficult cases.
No.
The reason is because the law in Michigan, ever since the case of Lugo,
Lugo, L-U-G-O,
Lugo, the 2001
Right.
Michigan Supreme Court case called Lugo. Ever since then, there are very few lawyers who want to practice in this area. And in fact, you get a lot of calls from people who have tried other lawyers and who have been turned down, or other lawyers have taken their cases and then decided to drop their cases. Because ever since 2001, when the Michigan Supreme Court, in essence, said, you have to put your nose to the ground when you are walking, it's been very, very tough, correct?
Extremely tough.
Extremely tough. I think the studies that I have looked at, Attorney Howard Radner, say that the largest number of injuries actually happen worldwide, not because of car accidents, but because of unintended falls. Correct? Have you come across those studies?
I have not seen those studies.
I look forward to sending this information to you because it is very true. We should also say that the reason why you often settle your cases in the hundreds of thousands or even more than 1 million is because a simple fall can often result in very serious injuries. In fact, just yesterday, I was reading an article by about the actor Liam Neeson. The actor Liam Neeson, who was married to actress Natasha Henderson, I believe, or Richardson. They went on a ski trip about 10 years ago, and she was practicing on the baby bunny. She fell, and she was okay immediately after the fall. They called the paramedics. She said, I'm okay, and she walked back to her hotel. And few hours later, the paramedics were called again, and she had suffered an internal hemorrhage inside her brain, and she was pronounced dead that same day. The article was written because now his nephew, who had also fallen 4 years ago, just died because of complications from a fall that he sustained 4 years ago. I will tell you that the future Queen of England, the Duchess Camilla, the wife of Prince Charles, her brother was giving a speech in New York at a hotel. I want to say it's the Carlisle Hotel, but I'm not sure. About 6 years ago, he walked out on ice, right out of his hotel. He fell, he suffered a concussion and a hemorrhage and died. So these are serious, and it can be a serious injury. It can be as mild, so to speak, as an orthopedic injury, like breaking your arm or your foot or your leg, but it can be more serious than that. So the first thing I think, Attorney Howard Radner, we want to tell people is to be very careful. Would you agree with me that in today's world, with the increasing use of cell phones, the likelihood of being distracted while you are walking has gone up?
Absolutely.
Yeah.
Oh, sure.
And in fact, there are a number of city ordinances across the country that fine people for distracted walking, because you can now fall, you can trip, because you are even more distracted by this mini computer that you are holding in your hands. So before we start about this subject, I just wanted to let it be known to the listeners that this is a serious topic because of the potential serious injuries that can result. And we want to remind each other, I want to remind myself first, and remind each other about, the need for exercising as much caution as possible, especially in today's world, in light of the fact that we have the phone in our hands all the time, and we're walking and we're looking at our phone rather than walking to see what's in front of us and to see what we are walking on. So, رامي, هيدا الموضوع حبينا نحكي عنه اليوم لأنه مهم جدا. في دراسة فرجت أنه أكثر عدد للإصابات بالعالم هي مش حوادث سيارات، هي بسبب انزلاق، لأنه اللي ممكن يصير بالانزلاق لا سمح الله هين تكون كسر إجر، تصور تكون إنه صار شي بالدماغ وصار في نزيف بقلب الدماغ. أعطيت إكزامبل لهوليوود أكتر كتير مشهور اسمه ليام نيسون، مرته ناتاشا ريتشاردسون، بريتش أكترس مشهورة كتير كانت. راحوا يعملوا تزلج من 10 سنين بكندا، وكانت على البيبي باني لأنه ما بتعرف تتعلم، وقعت ضربت راسها، ما حسيت إنه بها شيء أبدا. إجوا الباراميديكس، قالت له إنه I am fine، راحت مشي على الأوتيل تبعها. من بعد كم ساعة رجعوا طلبوا الباراميديكس، صار عندها بسبب وجع الصداع والدوخان طلع إنه كان عندها نزيف، والنزيف كان له من وقت ما وقعت كان عندها نزيف، ولأنه رفضت إنه تروح على المستشفى ليعملوا لها كات سكان، لربما، وهيدي نقطة بدنا نوصلها للمستمعين، لربما إذا راحت على المستشفى دغري يمكن كانوا قدروا أنقذوها، بس ما حست إنه في، يمكن حست إيديها إجريها أرفاين، ما فكرت براسها
يكون عندها نزيف.
نعم، سو الظاهر إنه النزيف بلش من الأول، ومن بعد كم ساعة رجعوا طلبوا الإسعاف وتوفت. واليوم امبارح حطوا الخبر عنه، عم بيذكروا عم بيقروا، لأنه ابن أخته كمان توفى امبارح من 4 سنين، وقع، كان شربان ووقع، وصار له 4 سنين عم بيعاني من الألم ومن المشاكل لراسه، توفى بسبب امبارح. كنت كمان عم ذكر المستمعين إنه أخت خي الملكة the future queen of إنجلترا Duchess كاميلا اللي هي زوجته لبرنس تشارلز، خيا كان بنيويورك من شي 6-7 سنين. he was giving a talk بواحد من الهوتيلز بنيويورك سيتي، طلع من الأوتيل وزحط، وكمان صار معه نزيف بدماغه وتوفى. عم نحكي مش بس عن القانون وإنه قديه القانون صعب، بدنا نحكي قبل القانون والأهم من القانون، لأنه مسار الدنيا كلها ما بترد الصحة ولا بترد الحياة. أول شغلة بدنا نحكي عنها إنه الوقاية، لأنه رامي في عنا إشياء خارج الكنترول تبعنا، التلج إذا منطفين منيح، بس شو بنلبس بإجرينا، إنه نكون حذرين نمشي، إنه نطلع للأسف مش بس قدامنا وعلى الأرض الاثنين، ونحاول ما نستعمل التليفون. نحن كلنا وأنا أولهم نترك السيارة التليفون بإيدنا، عم نشتغل على التليفون نحن وماشيين.
صحيح.
يعني نحن وماشيين عم نشتغل على التليفون، ومفروض نطلع قدامنا، ومفروض نطلع على إجرينا وين عم ندعس. كتير خطرة، هيني إذا إنسان كسر إجره مقارنة من أنه لا سمح الله يصير عنده نزيف،
صح، أو إصابات بالعمود الفقري يعني
exactly إيش ممكن تسبب لا سمح الله شلل. حبينا بالأول نحدد أهمية هيدا الموضوع. قبل ما ناخد اتصال، نحن اليوم بعرف في عنا متصل، إذا ممكن ينتظرنا تقريبا شي 10 دقايق قبل ما ناخد اتصال مع المحامي هاورد رادنر اللي عنده 44 سنة خبرة في قضايا الانزلاق، slip and fall, trip and fall، وهو من المحاميين القليل اللي صاروا بولاية ميشيغان اللي بعضهم بيتقبلوا هول الكيسز. قالنا كمان انه بياخد تقريبا 1%، يعني من كل اصل او واحد من اصل 20، يعني من كل اصل 20 اتصال نحن بنبعث له هن يمكن ياخد منهم 1 or 2 cases قد ما القانون صار قاسي. The first thing I want to ask you is, when somebody slips or trip and fall, how much time do they have to file a lawsuit?
3 years.
Okay. So the first point we want to bring across is that you have 3 years to act. Right. If you slipped and fell today,
unless it's against the city, then it would be 2 years.
Okay.
And if it's against the city, you must notify the city in writing within 120 days.
Of when it fell. 120 days is 4 months. 20 days notice. So the general rule is, if you slipped and fell anywhere not in a city, you have 3 years to sue from when you fell. However, if you slipped in the city, you have 2 years to sue, but there is an additional requirement. Within 120 days of when you fell, within 4 months of when you fell, you must be notifying the city in writing of the fact that you fell. And if you don't notify the city, you will be barred from filing a lawsuit. So yes, it is 2 years if you did the first thing that's required of you to do, which is notify the city. I want to talk to you next about, we can talk for hours, and I hope that you will be here again and again and again. I want you to list for me many of the verdicts that you have had before we talk about 2 areas, because we have half an hour left. You had a $2 million verdict in Flint against an apartment complex because somebody fell on a wobbly handrail and it made the news, correct?
Yes.
Okay. Read me some of your other verdicts.
There was also one in Flint, Joumana, where a gentleman was jogging on a public sidewalk at about 1 a.m, and he didn't realize it at the time because it was dark, but there was a protruding guardrail that was abutting into the city sidewalk because it had been struck by a car 3 weeks before, and the city had not repaired it.
Mm-hmm.
And this gentleman,
what was the verdict? You tried the case, and what was the verdict? We tried the case,
and the verdict ended up with, including interest, at $833,000. Now, this is a gentleman who had contacted various attorneys in Flint, and they all turned him down.
Because it's open and obvious?
Sure.
Okay, and we're going to talk about that.
And then he called me.
Okay. And you've gotten a lot of these calls where people have called other lawyers and they have been turned down, and they're like, okay, let's try one more time, or let's try one more person, sometimes through my office. And we've, directed them to you. Tell us about some of your other verdicts.
So recently there was a young lady that you referred to me who fell leaving her condominium early in the morning to go to work.
That's the 400 and some
No,
thousand.
this was 240.
$240,000. And what happened there?
What happened there is that she fell and broke her ankle as she walked out of her condo, heading toward her car in the parking lot. She fell on her icy sidewalk. Now, she went to a big PI firm,
Personal injury law firm,
in our Detroit area, and they were able to get a $10,000 offer for her, and they presented it to her, and she didn't want it, and they told her then they couldn't help her. And then she called you, and then you referred her to me, and we filed
because
the case.
I'm smart, and I know that you are the expert in this, way better than I would.
Oh, you're very kind.
It's very true.
So, thank you.
What about the recent case that I've also referred to that you settled for settled or tried for about 400 or 500? You wouldn't stop telling me how nice those clients are.
That's right. Those were people. No, that was settled for $197,500.
$197,000. Okay.
What
was the injury and what was the negligence?
One of the ladies had a broken wrist. One of the ladies had a broken ankle. They were invited to a birthday party, a surprise birthday party in Ypsilanti, to a home. It was a ladies' gathering, and they arrived there about 12 noon.
Yeah.
One of the ladies fell on the driveway on ice, and one of the ladies fell on the sidewalk on ice.
Okay.
So, yeah, we just settled that case very recently.
Tell us about some of your verdicts in a big store, like a Meijer or a Kroger or a Costco, for example.
Right. Well, there was a trial case that you referred to me. A lady went shopping at a food store. There's a puddle of water on the floor of the store, and that was because there was they were flushing out one of the refrigerator units, and it accumulated on the floor. So she was shopping. She didn't see the water. She fell and she injured her back and her knee. And so we went trial on that because the store did not offer us any money.
You tried the case.
We tried the case. The case evaluator said it was worth $40,000.
And the jury?
They turned it down, and the store turned it down and offered nothing. The jury returned a verdict of $236,000, but they found our client 15% at fault.
Okay, well, that's beside the point. What about any settlements or verdicts in the context of a landlord-tenant? People who rent maybe injuries for handrails, common areas, sidewalks right outside of your condominium complex or your apartment complex.
Well, there was a young lady who broke her wrist leaving her apartment on ice, and we were able to settle that for $200,000. I want to point out to your listeners, there's also sometimes workers leave their place of employment, they fall, and a lot of lawyers would tell them, well, you can't sue because of workers' compensation. You can't sue your employer for negligence.
Which is true,
now,
generally speaking, workers' compensation, but that's only within the scope of the employment.
That's true, and
once you leave,
there was that's true. But there was a case where the lady fell walking into the place of business, broke her ankle, and most people would think right away that there's no suit there because you can't sue your employer. But it turned out we did a little searching, and we found that the owner of the property was not technically her employer.
Right.
It was related to the employer, but it was a separate corporation. It may even been owned by the employer, but it was a separate corporation that owned the property. So we were able to sue the owner of the corporation because the corporation wasn't technically, in the eyes of the law, the employer. So she wasn't barred. We collected $365,000 for her fractured ankle in that case. So just because somebody falls going in or out of work doesn't necessarily mean that there's no case.
I think that the best thing to do, especially in the area of slip and fall, I mean, I'm a lawyer and you've educated me many times, and my office has done those on occasion, these cases, it's better to call and inquire and find out rather than to assume.
That's true.
Even if you think it is work related and you think that you'd be suing your employer and the law prevents you from doing that, find out because where you fell may be owned or operated by somebody other than your employer. Before we move on to the law, because I want to spend time educating people about the law, are there any other verdicts that stick out in your mind, either because of number or because of the egregious facts or because it's been turned down? Please tell us.
Yes. There was a lady who fell at her apartment complex on the grounds. They had a picnic table there. They had a little stream of water, a big area where people could go and have a picnic outside the apartment building. She was walking on the grassy area. She stepped into a hole and broke her ankle. Now, this was a case that was handled by one of the biggest PI firms in Michigan, and they had it for about a year or so. And
they filed the lawsuit?
They did not file the lawsuit. They investigated it, but they didn't file it.
They were sitting on it.
And she was getting impatient, so she called me. And I filed a lawsuit for her. There was no offer. The landlord was very adamant that it was open and obvious, and he didn't know about the hole. So we sued, and there was no offer at any time. They tried to throw the case out of court. The judge denied
for
it.
summary disposition.
Right? And the judge denied it. They took that up to the Court of Appeals. So the Court of Appeals denied leave. Then we went to trial, and she got a $200,000 verdict. Then they appealed again to the Court of Appeals. And while it was in the Court of Appeals, we settled it for $190,000.
Okay, $10,000 less.
Less.
Okay, congratulations. Any other verdicts or settlements that you want to share?
There was a young lady who went to visit her daughter at her husband's dwelling. This was a divorced couple, and she and he shared had joint custody of the daughter, and she, even when the child was staying at the ex-husband's house, she would periodically go there and give her a kiss goodnight, and would see her at some point during the time that she was with the father. So one night this is a case you referred to me, by the way. One night she went to give the daughter a kiss goodnight, and as she left the home, she went down the stairs, the wooden stairs. One of the stairs gave way, and she fell and broke her ankle. And so we sued the landlord, and we sued the tenant. The father was actually the tenant of the house. So we sued the tenant and we sued the father. Now, the difficulty in this case was that the landlord was not insured, which is unusual. Usually the landlords are insuring their property, and almost always, especially in the suburbs, this was in the suburb, the rental properties are insured. And this landlord did not have insurance on the property. The tenant, interestingly, did have insurance, and that's unusual because tenants often don't have insurance.
And that's exactly why you decided to sue the ex-husband. It was a tactical.
So we sued both. We sued the ex-husband.
What was the policy on the renter?
The amount, I don't remember, but it was fought very vigorously by both defendants. They claimed that there was nothing wrong with the stair, that it had been fixed already, and that if there was anything wrong with the stair, it was open and obvious.
Then she should have been. She
had been there many times because she went to visit there all the time to give her daughter a kiss goodnight.
Right.
So she didn't. She prevailed. We ended up settling that case for $105,000.
Congratulations. Landlords, you've said to me when we were preparing for today's radio program, better be insured. You had a $500,000 judgment against one landlord, and unfortunately you went to execute on the judgment. The landlord, who was not insured, filed bankruptcy, but you were able to get rid of execution and force him to sell the building. We'll talk about that in greater details. I want to remind the listeners that we are talking today about the law of slip and fall, and the first point and the most important point, the law is the law. And, there are some wonderful lawyers, very few of them, who, do a very, very good job. And Attorney Howard Radner is one of them. True and Tried has been the go-to, has worked for me, works with me. doing slip and fall for 44 years, his verdicts, that means that he goes to trial, he fights, because in these cases, they give very little. They offer very, very little money. So they make it easy for you to go to trial. He has fought, and he has a sheet of verdicts and settlements that speaks for itself. But the very first point and the most important point is we want people to avoid slip and fall. We want people to be careful. We're talking, when you end up filing a lawsuit, you're saying that the person couldn't have done anything, couldn't have seen it, couldn't because it is dark, because, you expect the handrail not to be wobbly, because you expect stairs to be sturdy, because you expect the walkway, which is your only way of leaving your apartment to your car, to be de-iced. We're talking about situations where people, no matter how much due care they have used, could not have avoided what happened. But very important in today's age of technology is to be extra careful. Like I said, there are now ordinances throughout the country against, it's a violation, like a ticket. You get a ticket for that and you pay money for that, called distracted walking. So anybody who wants to call today, we would appreciate if the call or the comment is about slip and fall, trip and fall. Should we take a call? Okay. We'll take a call, then we'll talk about landlord-tenant, then we'll talk about the number one calls that he gets, which is people falling inside stores, malls, Kroger's, Myers, and places like that. Okay, let's take the first call. Hello? Hello?
Probably we missed the call.
Okay. Whoever wants to call is welcome too. We have 20 more minutes. You said that we know that very few lawyers take slip and fall, trip and fall. However, you're more likely to find a lawyer because the law is much easier if you fell within the landlord-tenant situation. So a lot of lawyers don't take cases, but of those who do take cases, they'll take the easier cases because the law is easier, and that's the law in landlord-tenant. So now we're talking about people who rent, and there are duties. The law says there are duties on the part of the landlord, and if those are violated, then, and if it results in a slip or a trip, then you can sue the landlord. Tell us a little bit about the law of landlord-tenant. What is the landlord legally responsible to do and give his or her tenant?
Well, there's two different bases.
And here I ask you to keep it very lay.
Sure. The landlord is required to maintain his property to protect the safety of his tenants and visitors. This comes from the common law. And
meaning it's judge-made law.
That's right. And we also have a statute in Michigan. The statute requires that the landlord maintain all of the common areas fit for the purposes intended, and he also is required to repair the property. Okay, so
the duty of a landlord is to keep the certain areas fit for the purposes intended. And the common areas, they're like the stairways, they're like the reception area, they're like the parking lot, they're like the sidewalk. That's the only way for you to leave your apartment to get to your car. He has a duty as a landlord to keep these fit for the purposes intended. So, for example, if it's a stairway, of course it's expected that you will hand on to the handrail. You don't expect the handrail to come out and be wobbly, causing you to fall. If you go down on the stairways, you expect every step to be, in good condition to carry you from point A to point B. If it is the reception area, if it's the parking lot, you don't expect holes there, sidewalk, and all of that. You also said that the duty of a landlord is only vis-a-vis his or her tenant, but not a guest visiting the tenant.
As far as the statutory duty is concerned.
Okay, yes. As far as the statutory.
The common law requires them to maintain property for guests as well.
Okay. Without complicating it a little bit, we're also going to add that the duty of a landlord is to keep things in reasonable repair, like lights not working and broken windows and ceilings and so forth, correct?
Yes.
Okay. So أول شيء حبينا نحكي عنه إنه وقت في كتير عالم تستأجر والصاحب الأجار عنده واجبات قانونية، وبلا ما نعقدها شو القانون اللي الليجيسليتشر كتبته، شو القانون المحكمة اللي عنه. واجبات قبل كل شيء، أول نقطة إنه واجبات اللاندلورد هي بس تجاه اللي مستأجر عنده. يعني إذا إجا حدا زير المستأجر اللاندلورد وصار عنده إصابة، اللاندلورد ما عنده واجبات تجاه هيدا السوشيال جاست. يعني رامي إذا أنت بتعرف عائلة مستأجرة بمحل معين وإجا حدا زيرن وتعرض لإصابة، صاحب الملك منه مسؤول قانونيا، ما إنما صاحب الملك عنده مسؤوليات تجاه المستأجر عنده. المسؤوليات هي to keep things fit for the purposes intended، يعني الأشياء تكون للهدف اللي هي. مثلا إذا كان درج، الهدف إنه يوصلك ينزلك الدرج، يعني مفروض كل درجة تكون صالحة، مفروض كل الهاند ريل يكون صالح، في common areas هيدول لازم يكون ما لازم يكون فيهم holes، ما لازم يكون فيهم شيء على الأرض، زيت مي إلى آخره. الباركينج لوت، السايد ووك إذا صار في تلج، إذا صار في جليد وهي الطريقة الوحيدة لتطلع من الأبارتمنت تبعك لحتى توصل على سيارتك، عنده واجبات إنه هيدي كلها تكون fit for the purpose intended and he has a duty to reasonably repair it. يعني مثلا أضوية مش ماشية، broken windows، السيلينج إلى آخره. Very quickly before we take one of the calls, let's talk about notice to the landlord, because that's also important in certain areas.
Sure.
So is it that if the ceiling fell down, the landlord is automatically liable? Is it that if the stairway or the handrail is wobbly, then the landlord is automatically liable? Or?
Absolutely not. The landlord is not automatically liable. The landlord has to know about the defective condition of the property, or he should have known about it.
Okay, so no is when you saw something, you called your landlord to fix it, and she or he did not fix it. The second part of it is he should have known. Okay, how would the landlord know that there may be a wobbly railway?
If nobody complained,
handrail, excuse me.
Sure. If nobody complained, the landlord still has a duty to inspect his property periodically.
Okay.
To see
so that's the key.
Safe.
So if the tenant calls the landlord and says, Mr. Landlord, something needs to be fixed, there is a duty to fix it reasonably. And if an injury arises because the landlord knew and did not do anything about it, that's way easier. Or he should have known, because the landlord owning this place and benefiting from all this passive income also has duties under the law to make the rounds and look at things around, correct?
Correct.
Okay. So you said that the law is gentler, and that's why you'll find some lawyers taking cases when it is a tenant in a tenant-landlord situation. Then when we have a situation such as somebody falling at Myers or in a supermarket or at a mall, because there you have that open and obvious. Before we move on, and you did say to me though that many more people call you because they fell in areas like Meyer and the mall and the supermarket than people calling you in landlord-tenant, because not everybody rents. But everybody goes to the store, everybody shops, everybody has needs. So there is much more traffic going into Meyer and places like that, and many more people shopping. Everybody shops, but not everybody rents, correct?
Correct.
Okay. Before we move on to that second area, which is much, much harder, and where very few lawyers take these cases, let's take a call. Hello.
الو مرحبا.
يا أهلا وسهلا.
كيفك مدام جمانة؟
ماشي الحال. مع مين عم نحكي؟
غربة.
يا أهلا وسهلا سيدي غربة. هل عندك سؤال بخص الانزلاق؟ أوكي.
أنا تقريبا بال2012 يعني مش متذكرة التاريخ بالضبط، كنت نازلة من بيتي على الواك سايد. كان وقتها
على السايد واك قصدك؟
على السايد واك.
أوكي. وبيتك أنت بيتك أنت بتملكيه ولا مستأجرتي؟ أجر. أوكي.
اوكي. كان اجى الباص، ابني بيروح على سبيشال سكول، عم بعطيه حامله ابني بدي وصله على الباص. فنزلت من بيتي وصلت على السايد واك. هلا انا مش منتبهه، كان وقتها هلا انا اللي تضيف الثلج علي، عاملين اتفاق مع صاحب البيت.
اوكي.
ما كان في ثلج على لا السايد واك ولا مطرح ما بنزل من بيتي، كله منطفيته، بس بتعرفي على الجراس بيبقى بيبقى. فطلعت الشمس بيومها وبلش يدوب شوي وبينزل لتحت. هلا انا مش منتبهه انه في الارض مش مزبوطه السايد واك، لبعدين اللي انتبهت لها، فصاير نازل المي وصاير ترانسبارا يعني شفاف.
نعم، جلد.
ايوه، ما بيبين لك انه في.
نعم.
وبلش هيك ينزل هيك ثلج على الخفيف يعني. شيء انه هيك عم بيغطي الارض الثلج، فما بيبين تحت شو في منه اساسا يعني، ولانه هو شفاف ما بيبين. فزحطت وصار عندي كسوره، اجى الامبولانس اخذني وكل شيء. هلا بعد منا انا صرت اعمل 3 عمليات. اوكي. بعد منا رحت عند محامي، فقال لي انه السايد واك هيدا للبلديه تاعت ديربون، يعني ما فيك تعملي عليهم شيء. هذا شيء مزبوط او لا؟
Okay. Oh, I have so much to tell you. Okay, so the sidewalk belongs to the city of Dearborn, so you cannot do anything. Okay. Well, all right. So many things to talk about. First off, this lady back in 2012, so we have a statute of limitation issue, had an injury. The injury is over ice that she could not see, that's under snow. The interesting part, she has had 3 surgeries since. The interesting part is she had an agreement with her landlord that she is responsible for cleaning the sidewalk, leaving from her rented house into where she was holding her son and taking him to the school bus. She went to an attorney who told her, according to her, you cannot do anything because the sidewalk is owned by the city of Dearborn. So, first, the statute of limitation is 3 years. That means that whether it is 2 years?
Against the city.
Oh, I'm sorry. If it is against the city. If it is against the city, it is 2 years. Assuming it is against the city. If not, it is 3 years. But even if it is 2 years, you should have put the city on notice. سيدي غربة، أول شغلة بحب أقول لك إنه سلمي جدلاً، لأن إحنا ما بنعرف اليوم إذا السايد واك هو لمدينة ديربون أو نوت. القانون بيقول أنت أيمت رحتي بأي سنة حكيتي مع المحامي؟
بنفس بعد فترة ما طلعت من المستشفى.
يعني ضمن سنة؟
أي أقل من سنة، أقل من سنة بكتير.
أوكي، ضمن أول 4 أشهر من الحادث؟
تقريبا فينا نقول هيك.
She consulted with an attorney within the first year and probably within the first 4 months. هل المحامي قال لك إنه إذا بالفعل السايد واك هو لمدينة ديربون، إنه قانونيا لازم يبعت رسالة، إذا أنت عينتيه لازم يبعت رسالة لمدينة ديربون ضمن 120 نهار من وقت الانزلاق؟
لا، قال لي ما فيك تعملي، لانه لغوه هيدا القانون. اذا زحفتي انت على الشارع بتكوني انت مسؤوله، مش ما عادت السيتي مسؤوله.
That's not true. The lawyer allegedly told her that they canceled the law where, you know, they made away with the law where you can sue the city. If you fall on a city sidewalk, then you are responsible. To your knowledge, is there any such city ordinance in the city of Dearborn?
If she fell on ice on a public sidewalk, she cannot sue.
Well, but that's different. We're talking statute of limitation first. Because as far as statute of limitation, can you still sue the city of Dearborn? Yes or no?
Yes. 2 years.
Yes. So any city, whether it's Dearborn or Dearborn Heights or Detroit, you have 2 years, but you must be notifying them within the first 120 days.
Sure.
So بغض النظر إذا الحق معك ولا الحق عليكي سيدي غربة، ويمكن المحامي اللي حكاكي اطلع بظروف كيف وقعتي وقرر إنه أنت بسبب الطريقة اللي وقعتي ما في إهمال من قبل المدينة، بس اللي عم بتقوليه إذا فهمتيه صح هو خاطئ. بحقلك إنك تقيمي دعوة بالمكان المناسب ضد مدينة ديربون، مش لأنه وقعتي على السايد واك بمدينة ديربون. ما في قانون بيقول لأنك وقعتي على السايد واك وبتملكها المدينة أنت ما فيك تقدمي دعوة. هلأ إذا أنت بدك تقيمي دعوة ضد المدينة، أول شيء بدك تبلغيهم ضمن كتابيا ضمن أول 120 نهار. that's number one. ونمبر 2 بدك تفرجي بعض الأشياء لتقدري تربحي الدعوة. بس هيدي أول شغلة عم تقوليها هي غلط. أوكي؟
هي راحت وقتها. أنا مش عم بسأل لأنه بدي أرجع أعمل دعوة أو أي شيء، يعني حتى أنا على صاحب الملك ما عملت دعوة.
يس، بس نحن عم نستعمل الكيس تبعك كمان لنعلم بعضنا البعض عن القانون.
مزبوط. أنا بشكرك كتير هالحلقة لأنه بتفيد كتير عالم.
Thank you.
هلا شغلة الأولى إنه مثلا السايد واك هلا مش مفروض السيتي إذا في أي أعوجاج أو المي بتعلق فيه أو أي شيء، مش هي السيتي تكون مسؤولة إنه تظبطه ولا صاحب البيت.
So her question is, notwithstanding that the time has passed and she cannot sue anymore, she wants to know whether a city has a duty to keep its sidewalks, because she says that there is a hole there where the water was accumulating and turned into ice and it was covered by snow. Does the sidewalk, let's say this injury happened, this accident happened a week ago. We are fine. We still have plenty of time for the 120-day notice. Do you not agree that the city has a duty to fill that hole?
Sure.
Okay. How would the city know? Should somebody be notifying the city that they saw a hole, or they too have a duty to reasonably go and check their sidewalks and their streets?
They do have a duty. There are cases that say that.
Okay.
They have a duty to inspect their streets and sidewalks.
Okay. So they have a duty to regularly inspect streets and sidewalks. And the argument would be here, had they done that, they would have discovered that there is a big hole there that is being covered by ice.
And there's one other rule also, that if the hole is there for 30 days or more, then notice is presumed.
Okay. And how do you prove that a hole has been there for 30 days?
You would have to get a witness to say that he or she knew that there was that hole there for at least 30 days before the person fell.
Okay. So سيدي غربة، لحتى نستعمل هيدا المثل كإكزامبل لكل المستمعين، بيقول المحامي هاورد رادنر إنه كل مدينة عندها واجبات إنه periodically regularly، يعني بطريقة دائمة، يروحوا يفحصوا الستريتس تبعهم والسايد ووكس تبعهم. يعني إذا لحضرتك عم بتقوليه مزبوط، لو حصل امبارح كنا منقلك it looks like you may have a case. اوكي. واذا كان إلى اكثر من 30 نهار وحدا مثلا نقول جيرانك بيشهدوا انه من قبل من شهر وشهرين شايفين انه في كان هول هونيك والسيتي ما عملت فيه شيء، كمان يعتبر قانونيا كانه عندهم علم وخبر. يعني عندها واجبات المدينه انه دائما تروح تفحص الستريتس تبعها والسايد ووكس تبعها. الشغله الثانيه اللي بدي اساله اياها لانه انا ما بعرف، can she give away in the landlord tenant contract her right to have the area cleaned by the landlord? Because apparently she did agree with her landlord that she will be responsible to clean.
No, those clauses are invalid.
Oh, really? Okay, so let's talk about that. سيدة غربة، الاتفاق اللي كان بينك وبين صاحب الملك انه انت اللي بتاخدي على عاتقك انك تنظفي الثلج، يقول المحامي انه هيدا اتفاق غير قانوني، لانه هيدي واجبات، these are statutory duties.
Statutory duties.
اوكي. هيدي واجبات قانونية على صاحب الملك، ما بيقدر يتخلى عنها. حتى لو قال لك بعطيكي أجار أقل، حتى لو قال لك I will give you a cheaper rent.
اوكي. نحن وقت اللي رجيت انا استاجرت البيت ما قال لي انه بعطيك اجار اعلى ومال، بس بالعقد مكتوب انه التنظيف السنو علي.
Okay, so the contract says the landlord tenant contract says that she is responsible for cleaning ice and snow. You say, Attorney Howard Radner, that there is an invalid clause. She can sign, but that does not mean that it is legal in a court of law. So العقد هو غير صالح لأنه ما بيقدر قانونيا يتخلى عن هيدي الواجبات. نحن بنشكرك على الاتصال، عنا فقط 4 دقائق، بدنا نحكي شوي عن الإصابات in a mire أو in large areas. Very interesting scenario. She did not act within the statute of limitation. She entered into a contract with her landlord that is partly invalid because he had duties that he tried to put on her that he cannot do. And there was another issue here. And she was advised wrongly. She did not give a notice, and it is too late. And she had 3 surgeries. That's very, very sad. Very sad. We have about 4 minutes remaining. You promised that you would come as best you can, maybe once a month, and we can educate listeners about this law. Let's talk about, people who fall in mires. Let's talk quickly about the notice provision, that just because you fall does not automatically mean that Myers is wrong and Costco is wrong and the shopping mall is wrong.
Sure. People often will call and they'll say they fell on water, fell on a grape, fell over a crate, fell over some item that was on the aisleway. 99% of the time, there's no basis of liability there on the part of the store
No case
owner.
Because?
There's no notice.
Okay, and let me explain secondly, what notice is. Yeah. They too, much like a landlord, have a duty every so often to walk the aisles and make sure everything is safe. But if something happens between the time they walked and the next time they should have walked, they didn't know about it, and so tough luck.
That's true. And
the other thing is too that...
The other thing is open and obvious.
Yes, and let's explain. That's why the law in Michigan is so tough. And that's why there are very few lawyers left to take these cases. Because in Lugo, from 2001, the Michigan Supreme Court said, in essence, you have to be like a dog and put your nose to the ground. And you're supposed to see something even if it is there. Even if something should not be there, you are supposed to see it. So رامي أغلبية الإصابات اللي بتحصل انزلاق بقلب السوبر ماركت بقلب المولات الكبيرة قانونيا ما بنقدر ننجح فيها لأنه كمان هونيك المول المايرز كمان عندهم واجبات مثل صاحب الملك انه كل مده بعد مده يعملوا برمه. اذا عملوا برمه بين البرمه والبرمه وما لقوا في شيء على الارض، اذا صار شيء لا سمح الله بين البرمه والبرمه ساعتها ما مسؤوليتهم. يعني اذا برموا على الساعه 12 وبيبرموا على الساعه 12 ونص وصار شيء بين ال 12 و 12 ونص they had no notice. لو عارفين فيه وما نظفوه هيدي شيء تاني. بعدين القانون هون صارم جدا. القانون هون بيقول حتى لو في شيء وحتى لو صاحب المول أو صاحب الستور أو صاحب السوبر ماركت عنده علم وخبر، ليش الإنسان ما شافه؟ وهون القانون بيكون كتير صارم. يعني كأنه عم بيقولوا للإنسان بدك تكون بعتذر مثل الكلب. الكلب بيمشي منخاره على الأرض، بيقولوا أنه أنت بدك تكون مثل الكلب منخارك على الأرض. الكيس عن شخص أعمى، شخص أعمى قالوا كان لازم يشوف. Lugo, wasn't that the blind person?
No, Lugo was a lady named Lugo who was walking in a parking lot with a pothole owned by Meritech.
But was there not a case,
there was
very
another case.
Egregious case,
yes,
where the Michigan Supreme Court said the reasonable person would have seen?
That's right. And
but the plaintiff was blind.
Right, because it's an objective standard. It doesn't matter in the eyes of the law here in Michigan whether the plaintiff saw the condition, but whether a reasonable person would
have
see
seen.
it. An ordinary reasonable person would see it.
Thank you very much, Attorney Howard Radner. Time went by very fast. I hope that we can have you again. Thank you for all the clients that come to me, that you help and that you serve and that you get a fair outcome too. Thank you لكل المستمعين. شكرا للمتصل اللي علمتنا كتير. شكرا لرامي.
شكرا لك جمانة. أكيد نذكر مستمعينا برقم الهاتف في مكاتب المحامية جومانا كيروز 248-557-3645 248-557-3645 والاستشارات مجانية. بإمكانكم أيضا زيارة الموقع الإلكتروني yourrights.com للاستماع لهذه الحلقة yourrights.com/radio. وأيضا بإمكانكم زيارة قناة الخاصة لجومانا كيروز على اليوتيوب والاستماع ومشاهدة هذه الحلقة. دمتم في رعاية الله وإلى اللقاء.